Uh, Today we will be studying PSIR 1B, that is Indian Government and Politics. Today we will be starting with the topic Constitution. My focus here will be to ensure that your short notes are complete so that you can revise them for your mains. And this is for PSIR students mainly, but PSIR students can use this content in GS2 Polity also. Other students watching who are not from PSIR background can also use the content judiciously wherever needed, because people are quoting scholars nowadays in almost all the subjects, but don't make it excessively academic. The topic is constitutionalism and constitutional morality. What is constitution? Then what is constitutional morality? Now, other aspect is history of constitutionalism in India. Now, arguments on constitutional morality. So now let's see what is a constitution. These are the broad areas that we need to cover. Let's start with the topics. What is constitution? So in simple words, constitutions are power maps. They are called power maps because they define the powers of different branches of the government. For example, in Indian setup, we can see how the Indian Constitution defines the state versus union distribution of power, the state versus state, the citizen versus the government, and executive, legislature, judiciary, everything, distribution of power amongst them. So that's what the work of constitution is. So basically, what is it doing? It is putting limitations on the government. Now what is constitutional morality? So it is clear that constitutions are the power maps. They're broadly the power maps. They put limitations on the government's powers, and thus ensure that citizens have some rights. And also the governments don't the branches of government don't infringe into each other's domain. Now, what is constitutional morality? So constitutional morality is the ethical commitment of the citizens. Ethical commitments of the citizens to uphold core constitutional values, to uphold core constitutional values, that is liberty, equality, justice, fraternity, etc. Right? So what is morality? Now, what is morality? Morality is anything that our values are based on. In ethics, we study morality. What is it? It is basically the ideas that we believe in. Now, these ideas can be based on our religion, our family values, cultural influence, anything. So when we are focusing that our morality should be derived from the Constitution, we are saying that the citizens of India believe in common set of values that are based on Indian Constitution. They are not arbitrary, they are not person specific, they are the core values that are enshrined in our Constitution. Now let's see what is the next topic. It is the history of constitutionalism in India. Now when we talk about the history of constitutionalism in India, first thing that might come in your mind, it is easy, since our constitution was enacted in 1949. That means that with the arrival of constitution, the constitutionalism came in India. That is false. Why? Because constitutionalism is far larger term and far wider term than constitution itself. For example, I can give you multiple examples from ancient, medieval, and modern period where we had some traces of constitutionalism. There were some ideals that were being followed based on common set of principles. For example, in ancient India, dharma was central in Arthashastra, in Manusmriti, and other shastras. Similarly, Dhamma was central in Buddhist political thought, that is Tripitakas. And scholars like Patrick Olwell has shown that laws were the central to both Hindu, Buddhist, and Jain way of life. We can see even today there are some set of rules that are being followed by various religious communities in India. So what are these? Can we say that these are some common set of principles that broadly the as dharma or as Raj Dharma, the political class is also following, the citizenry is also following. So that becomes some sort of proto-constitutionalism. Now, moving on to, there was concept of Gana and Sanghas. Let's move medieval a bit lower. There are more examples in ancient India. So, Gana and Sangha. They were early republics. And because they functioned in very distinct manner, they had some set of principles on which they function. In that way, they can be called as examples of constitutionalism, and actually Romila Thapar has made this connection. So they don't not only exemplify the constitutions of the constitutionalism and constitutional morality of the time, they also exemplify the early republic format of the time. Now, what we can also see is there were works like Tirukural and Ashtadhyayi of Panini, Yajnavalkya Smriti, all codified the morality of the time. Okay, so there was the thing of codification. Like today we codify our laws, similar thing was happening at that time also via Thirukural, Panini's Ashtadhyayi, and Yajnavalkya Smriti. There are many other examples. There is that Brihaspati Sutra and everything. All of these literatures, they include some sort of codification of laws. Now moving to medieval period. Let's move it a bit lower more. Medieval period. So when we see the medieval period, the primary event that took place during the medieval times was arrival of Islamic jurisprudence in India. So in Islamic jurisprudence there was Sharia, but along with that there was also secular law, the day-to-day functioning of the government, and many of the things are continuing to till today, because British later adopted their system, and now the independent India is also following some of the codification and things. Now what is the term that we can call this setup of dual layered administrative system? Because there were qazis who were doing the formal adjudication in both of these cases. So there are scholars who have called it dual layer. For example, Aisha Jalal has called this dual layered jurisprudence. And administration. Later we can see that Aini Akbari by Abul Fazl is a quasi constitutional document. And scholars, you can name scholar who has called it quasi constitutional, that is M. Athar Ali. Apart from this, in medieval times we also see the Vijayanagara Empire with their elaborate court system, and Bahamanis, the system later adopted by Marathas. So this is very lengthy format, but you can use some instances. That medieval also we had some examples of constitutionalism. In ancient times also we had some examples of constitutionalism. So in Marathas we can say that under Shivaji, Ashtapradhan essentially worked as council of ministers under Shivaji, right? So this was this. Then moving on to modern period. Now in modern times we can say that with the colonial colonial legal transplant of equality before law. Now this is very interesting term used by Upinder Bakshi. What is it? Is legal transplant of equality before law. This is used by Upinder Bakshi. What does this mean? This simply means that in Europe, in Britain, the equality before law as a concept developed because of the social and political circumstances. However, in India, it was simply transplanted by our colonial masters. They were not masters, but they did this transplant of the idea of equality before law. So what happened, that society was not at all equal at that time, but we were trying to just push equality before law. So maybe everyone is equal before law, but in society they are not. So obviously it didn't result in substantive equality. It was only on paper. So later we can see controlled constitutionalism. Controlled constitutionalism. This is the thing. Controlled constitutionalism is a term that is used for EIC rule. Why it is used? Because during EIC rule, the British Parliament tried to control the EIC rule in India. So they were bringing regulating acts and charter acts. Now, later when the crown gained the power under crown, British Raj, what we call it, strategic constitutionalism emerged. That was like giving some powers via 1909 Indian Council Act, then some powers via 1919 Government of India Act, then 1935 Government of India Act, but never devolving any real powers to Indians. So this is called strategic constitutionalism. Now apart from this, Indians were also trying to develop our own constitution. For example, Indian attempts Tilak's Swaraj Bill, it was in 1895. Then T.B. Sapru's Commonwealth of India Bill in 1923. Commonwealth of India Bill. And then there was Nehru report, very famous Nehru report of 1928. So this is the entire history of constitutionalism in India. We can minimize it a bit. Now let's see what are the. So we have seen till now that what is constitution, what is constitution now, and what is constitutional morality, and what is history of constitutionalism in India. Okay, so now we can see that constitutionalism is the way of governing, way of administration, way of living of people of a country, and constitutional morality is deriving the moral values from the constitution. There is very minute difference between the two, so they are often used interchangeably. Now let's come to arguments on constitutional morality. Constitutional morality, as we saw, Kautilya's Arthashastra speak about Raj Dharma. So that is a historical link. We can take that from there only. And now the question arises that we have seen that our constitutionalism was not dependent on the 1949 constitution that we have. It existed before this constitution also. So we can say that it exists even when constitution doesn't exist. It may not exist in some places, but in places it exists. It might exist without constitution. And a good example of that is Britain. Let me give one heading here. Written versus unwritten. So in unwritten constitution also, like Britain, constitutionalism exists, and this is shown by Dicey and Maitland. Their parliamentary conventions and parliamentary laws are sufficient to drive their constitutionalism. Okay, now in arguments on constitutional morality, we were saying that it exists before the constitution itself, and what is its necessity. So this is given by Dr. Ambedkar himself. He says it is essential constitutional morality. I will write CM for constitutional morality from now on. Is necessary to stand against grammar of anarchy. And what is grammar of anarchy? It is very famous term, you might have heard, but it is let's talk about it a bit. Grammar of anarchy. So Dr. Ambedkar was a firm believer in constitutional methods, and he was skeptical of what? The extra constitutional protests, hunger strikes, etc., the Gandhian methods. So what was his opinion was that in independent India we can't resort to the extra constitutional methods for anything that we need. We need to embody the constitutional morality in ourselves. We have to trust the constitution for anything that we have grievances against. So that was his opinion. Now, how is that, has it functioned in our democracy? We can see that 3 out of 13 judges, which was the case which had 13 judges? It was the very famous Keshwananda Bharti case. They say according to them that these 3 out of 13 judges, basic structure which they were proposing for the very first time in the Keshwananda Bharti case, the basic structure is actually based on constitutional morality. So it was their argument, and based on this, that the basic structure, doctrine, and the firm belief in constitutional morality, were the Supreme Court judges able to derive the expansive definition of Article 21, which led to judgments like Nas Foundation case on homosexuality, Navtej Johar case on homosexuality, and Indian Lawyer Association versus State of Kerala case, that is Sabrimala case. So these were very wide interpretations of Article 21 and Sabrimala Article 25. Also, what constitutional morality does, why is it important? We were discussing necessity, right? So in this example, in these 3 cases, we can see that what the judgment was, it was not very in line with, it was not in line with the popular opinion. Popular morality of India was not in favor of allowing homosexuality, or decriminalizing homosexuality, or allowing women in Sabrimala temple. So what judges were doing here was, they were making constitutional morality stands against public morality, which might not be very inclusive at times, which might be very biased, very bigoted at times. So that's why constitutional morality is necessary. We can simply see that justice is essential, liberty is essential, equality is essential. We don't and it might be in contravention to our personal morality at times, but when we keep constitutional morality at top, rights of every citizen can be ensured. In the end, we can see how Aristotle used to say that best constitution is which is attainable by all. If it is attainable by all, it must align with morality of all. So not only constitution should form the morality of the people, it should also be derived from the morality of people, as it happened in Indian scenario also. The idea of Sarvdham Sambhav, which was always there in Indian society, was adapted to shape the secularism that is enshrined in Article 25 to 28 of Indian Constitution. So that is one example. And constitutional morality and people, this is that link. We can write it like that. Not just people derive morality from constitution, but constitution also derives morality from people. And now we can also see that constitutional morality, as we have talked about here, that it is also present in unwritten constitutions. So it is not very legal and particularistic in manner. It is not very textual in manner. It can be extra textual. It can be extra legal. It is basically morality. Morality doesn't necessarily derives from a text. So what we can see here is other area that we can link it with, Habermas. Habermas has given the concept of constitutional patriotism. And what is this concept? It is nothing. This is very. It's Habermas. Habermas. This work was post World War II work. So he emphasizes an idea which is since the main reason behind the World Wars was hyper nationalism. So this idea discards hyper nationalism, constitutional patriotism. It says rather than focusing on our identities as a nation, we should focus on the values as a nation. We should give the priority to the values enshrined in our constitution. So if a US citizen, for example, he was talking about US citizens. So if a US citizen is keeping liberty at the top, so it won't matter if it is about liberty of US citizens or other nations' citizens. So here's the concept of constitutional patriotism, very similar concept as constitutional morality. We can also use it to enrich our answers. Now, Rawls. Rawls has given the concept of overlapping consensus. And overlapping consensus, although he gave in, I think, 1990s, but it was already present in Indian Constitution. See, India is a very diverse country. So there cannot be a consensus on every aspect of life. But there are certain areas where we as citizens of India agree upon. So that is very similar to what overlapping consensus says of Rawls. Now there are some challenges. Let's talk about the challenges here. It's nothing. The basic challenge that we have with constitutional morality is that it is vague and thus it is difficult to attain. For example, let's take equality. Now, liberals would say equality of opportunity. Marxists would say absolute equality. Complete redistribution of wealth, right? So there is no defined definition of equality in the constitution itself. In some places, our constitution does expand on it a bit, but there is not a clearly defined definition. Other thing with the constitutional morality is, for example, we saw that Supreme Court judgments are now being based on constitutional morality. What is it leading to? Excessive judicial discretion. Excessive judicial discretion. Excessive judicial discretion is bad because judges are not elected representatives of the people. They are there to interpret the law, not make the law. When the definitions are vague, what happens is there is a lot of discretion. And morality as a concept is supposed to be vague. It is not a clearly defined thing anywhere. So if we are over relying on constitutional morality, there increases the excessive judicial discretion, leading to judicial overreach or judicial activism. However, despite these challenges, it is essential to note that it is essential to note that morality based on constitution. Now we can write a crisp conclusion for your answer. Don't write conclusion in your answer. Matlab, don't write the heading conclusion in your answer. Morality based on constitution is necessary to kindle passionate attachment of citizens and prevent despotism. This is said by George Grote, who is considered to be originator of the term constitutional morality, and Dr. Ambedkar has quoted this only in Grammar of Anarchy, so it is very relevant quote. So here we are, constitutionalism and constitutional morality. We have discussed what is constitution. We have also discussed what is constitutional morality, history of constitutionalism in India. Then in history we talked about the ancient, medieval and modern events. Constitutionalism predates the constitution itself. Written versus unwritten constitution. The constitutional morality and constitutionalism both lie in any case. It can be written or unwritten constitution. Now, arguments on constitutional morality. We talked how Cordelia has talked about Raj Dharma and why is constitutional morality necessary. Now, here we have quoted Ambedkar, and then we have seen that Supreme Court judges have also shaped the idea of constitutional morality in India. Apart from that, we saw that what is the link between the constitutional morality and people, how Aristotle's idea relates with that, and constitutional patriotism of Habermas, then Rawls' overlapping consensus. So then we saw some challenges with constitutional morality, but overall it is very necessary to kindle the passionate attachment of citizenry and promote and prevent despotism, as George Grote has said.